Hi there, Catherine Cavella from IP Works Law. I am here to talk to you today about patents versus trade secrets and which one is a better fit for your invention. So patents last 20 years. They involve publication. You have to publish your invention to the world, and they're associated with a higher cost than some of the other forms of protection. And you should expect to spend anywhere between 10,000, 20, 30, 40, and up on patents to protect your invention. Trade secrets, on the other hand, they never expire. Caveat, but they never expire. They don't have a definite term, and they're protected as long as you can prove that you're taking measures to keep them secret. And so that tends to be contracts and actually things like safes and encryption. And they do not involve publication. That's one of the reasons that they last, because you obviously don't want to publish your trade secrets. So, you may be thinking, well, then why would anyone get a patent? Sounds like trade secrets are so much better. So there's a couple of limitations of trade secrets that are really important to consider before you decide to not pursue patents. So if your invention is the kind of thing that can be protected as a trade secret, as a patent, and not everything can. Some things have to be protected as trade secrets, like recipes. But if your invention is something that can be protected either as patents or trademarks, here's some things to consider before you decide which way you want to go. With a patent, you do have to publish, but your priority date is fixed and provable. And that can be very useful in a situation where a competitor reverse engineers or independently invents a process that's the same as yours, a process or an invention. So there's nothing wrong with reverse engineering. It's not illegal. So as long as they're not hacking into your computer or taking your employees' knowledge in violation of contracts, they're perfectly within their rights to try to reverse engineer your invention. If they do that and you only have protection as a trade secret, two bad things can happen. One, you lose the value of your trade secret because now it's not secret anymore. And it became not secret through no wrongdoing. Second, your competitor could get a patent on it. And at that point, then they can actually come after you. Now your trade secret, which you figured out first, is now infringing a patent. And then of course the other issue is that litigation tends to be public. It's in the public courts, and so enforcing a trade secret is a little bit more complicated and expensive and difficult than enforcing a patent. So those are three considerations to think about before you decide that trade secrets are the way to go. Again, Catherine Cavella, IP Works Law, ipworkslaw.com, and I'm looking forward to answering more of your intellectual property questions. Thanks.